Have a seat.
I'm not.
Have a seat.
Your Honor, I haven't had
Have a seat.
This opening exchange immediately sets a tone for a high-conflict courtroom interaction. The judge is asserting authority, repeatedly instructing the defendant to sit. This isn't just about seating, it's about control and compliance within the courtroom structure. Now notice the line, "Did you understand what I just said?" That's not casual. In legal settings, especially when someone is representing themselves, understanding instructions is critical. But here's the bigger question. Is this a simple misunderstanding, or is this a clash between legal authority and personal resistance? And when the judge says, "We are not going to agree to anything," it signals that negotiation is off the table. This is strictly about procedure, law, and control. What do you think? Should courts show more patience in moments like this, or is strict control necessary to maintain order?
Did you understand what I just said?
Can we agree to disagree on the legalese?
We are not going to agree to anything. This is not.
This is where the emotional tone escalates. The judge is drawing a very firm boundary. Court is not a place for tactics, delays, or what they perceive as games. In legal terms, this reflects a court's responsibility to prevent disruption and ensure proceedings move efficiently. But at the same time, this kind of statement can feel intimidating or even confrontational. It raises an important legal balance. How does a judge maintain authority without appearing biased or overly aggressive? Because while courts must stay in control, defendants still have rights to express themselves and challenge charges. This moment really makes you think. Where's the line between courtroom discipline and perceived pressure?
Your game to play here.
So you're saying that I have to say the words, "I understand"?
Sir, I'm not saying that you have to say anything. You can play games with me all day. I got all day. I got all day. Have a seat. Do not interrupt me.
I can object to
Do
that.
not interrupt. Do not. One more time. You're going.
In this matter, sir,
Yes, sir.
I do have to advise you that in this case, you are charged with the offense of assaulting, resisting, or obstructing a police officer. That is a high court misdemeanor felony, punishable by up to 2 years and/or $2,000 fine plus court costs. You understand that?
I understand your charge.
You understand also that there is great peril in one representing themselves. You understand that, sir?
I'm not afraid, Your Honor.
Did you understand what I just said? That there is great peril in representing oneself.
I comprehend what you're saying, Your Honor.
Hey, what?
This is a turning point in the interaction. The judge is now clearly applying pressure to get a direct response. In legal proceedings, clarity is everything. Ambiguous or evasive answers can stall or complicate a case significantly. When the judge says, "You're going to answer my questions properly," it's not just frustration, it's procedural necessity. The court needs a clear yes or no to establish understanding, especially regarding charges and rights. However, the tone here is undeniably forceful. This raises a critical question. Does pressure help obtain truth, or can it unintentionally intimidate someone who is already representing themselves and may not fully understand courtroom protocol? And from an audience perspective, do you think the defendant is being difficult, or is he genuinely trying to assert his understanding in his own way?
You're going to answer my questions, and you're going to answer them properly, or we're going to have a long time, and I'm not going to have these people wait. So while you decide how you're going to handle this, I'm going to have you have a seat. I'm going to pass your case. You will come back up, and you will learn how to operate within this court. Plain and simple. Have a seat.
Have a seat. And you might want to wipe that smirk off your face while you're doing it. State your name.
Good afternoon, Your Honor. My name is Daniel Magoo.
I have stated the admonishments that I was giving to the defendant representing himself. I apprised him of the maximum penalties and the charges. Apprised him, and sir, I'll ask you the question again. You understand that there can be great peril in representing yourself.
I fully recognize and acknowledge the seriousness of the charges, which include allegations of
Not my question. You understand that there can be serious peril in representing yourself.
I recognize what you're saying, and I'm fully prepared to proceed with this matter.
Will you just do me a favor and answer?
This is one of the most important legal warnings in the entire clip. Representing yourself in court known as prosa representation, comes with serious risks. The judge is legally required to ensure that the defendant understands those risks before allowing them to proceed. Why? Because the law recognizes that without proper legal training, a person can unintentionally harm their own case, miss deadlines, misunderstand evidence rules, or fail to challenge prosecution arguments effectively. So when the judge emphasizes great peril, it's not exaggeration, it's a formal warning. But here's the tension. The defendant doesn't just need to hear the words, they need to clearly acknowledge understanding. This raises a powerful legal question. Does simply hearing a warning count as understanding it, or must the defendant explicitly confirm comprehension in a way the court accepts?
Answer my question. Do you understand that there is great peril in representing oneself?
I recognize that.
Okay, let's stop there.
Yeah.
You recognize that.
Recognize.
Do you understand that that in any of the proceedings that the court would hold you to the same standards as if you were a practicing attorney, will give no leeway one way or the other, will show no favoritism or no bias because you are representing yourself? You understand that, sir?
I recognize what you're saying, Your Honor.
You know what? I don't know why you just won't.
This moment highlights a breakdown in communication that's becoming increasingly tense. The judge is trying to establish a legally binding acknowledgement of understanding, but the defendant keeps responding in a way that suggests partial or indirect comprehension. In court, this is critical, because later on, a defendant cannot claim they didn't understand if the record shows they confirmed it. That's why the judge keeps repeating the question in slightly different ways. However, from a human perspective, this exchange shows frustration building on both sides. The judge wants a clear answer. The defendant is responding with what sounds like semantic or philosophical language, recognizing versus understanding. So here's the big question. Is the defendant trying to be precise, or is this an intentional strategy to avoid giving a direct legal answer?
Understand. I'm asking you, and I need a direct answer, whether you understand what I am saying, not whether or not you're recognizing the words. Do you understand what I am saying?
I overstand what you're saying.
You want to be?
Your Honor,
You have a seat.
I'm not.
Have a seat.
Your Honor, I haven't had.
Have a seat. You can play games with me all day. I got all day. I got all day. Have a seat. The other one's in custody. I realize we are now at least caught up within an hour. I think those that want to go probably want me to take a break about now. So I'm going to take about a 5 to 10 minute break. I'll come back out and then I'll call the case. The court's going to stand in recess.
Good afternoon, Your Honor. Daniel Magoo. Here in Dewey Juris.
All right. So on this matter, I was apprised you of your rights. I told you about the charges in this case. We get to the point of understanding that there is a certain peril in representing.
Listening, sorry. My notes, I apologize, Your Honor. I meant no disrespect.
The court will treat you the same as an attorney in the case. You understand, sir? Listen closely to my question. Do you understand that?
I do not understand.
You do not understand it.
No.
The court, you will be presumed to know the rules of procedure as well as the Michigan rules of evidence, that the court will not be giving you assistance in regard to this case.
What I'm trying to say, Your Honor, is I do not understand the charges that are pitting against me because they violate a lot of my rights. And the prosecutor served me the discovery packet on the 27th of last month. Since then, I have not received any kind of evidence or any kind of claims that I violated any kind of anything that day. So I'm here waiting for that to occur. So no, I don't understand.
Waiting
the
for
charges.
what to occur?
Well, under the rights to due process.
Now the tone shifts significantly. The defendant begins referencing constitutional principles, due process, the Fourth and Fifth Amendments. This is a critical moment because it shows an attempt to engage with the legal system on a deeper level. Due process means a government must respect all legal rights owed to a person, including fair procedures and proper evidence before conviction. The defendant is essentially arguing that these standards haven't been met. But here's where things get complicated. Understanding legal rights is one thing, but presenting them in a legally effective and structured way is another. Courts rely on formal procedures, evidence rules, and clear legal arguments, not just general claims of rights violations. This moment raises an important question. Is a defendant making valid legal points, or are they struggling to present those points in a way the court can act on?
Process, Your Honor, Fourth, Fifth, Eighth Amendment. There has to be substantiated amount of evidence to accuse me of a crime, like assault on a police officer, obstruction of justice, and resisting arrest. I take these charges very serious, Your Honor. Because of these charges, I have lost custody of my son, and I want to make sure that these justice is served and equity is ensured here.
Sir, I just asked you before whether or not you understood the charges.
And I answered you, Your Honor. I said I do not understand them.
Whether or not you disagree with them or not, is not the issue. The issue is do you understand what you are charged with?
I do not understand, Your Honor.
Is there a reason other than what you said that you do not understand?
I can elaborate a little further, Your Honor. I'm still
I
waiting.
wish you wouldn't. I just need to understand why you don't understand.
I'm
the
trying to get there, Your
charges.
Honor, if we could talk
I'm
about it.
not asking you whether or not you agree that you should be charged. I'm not asking whether or not you
You're asking-
believe that you did it. I'm not asking any of that. I'm asking whether or not you understand what you are charged with.
Can we agree to disagree on the legally?
We are not going to agree to anything. This is not your game to play here. You play by my rules.
So you're saying that I have to say the words, I understand?
Sir, I'm not saying that you have to say anything.
Okay.
You know what? Here's the thing. I am not going to play this game with you.
I'm not.
So what? No, you are playing a
I'm
game.
not.
So no, you are. And do not interrupt me ever again. Do not. So what I'm going to do is I'm going to give you a week to think about it, because I'm not going to sit here, call your case up 4 or 5 times for you to sit here and to go through this whole, try to play some semantical game. So I will adjourn this out to December 12th, 2024. I will adjourn it to 9 a.m.
Your Honor.
or I will, do not interrupt me.
I can object to
Do
that date.
not interrupt, do not. One more time, you're going. I'm adjourning the proceeding out. If you are objecting to that, objections noted. It's still adjourned out to the 12th. Bond will continue. You
Your
may
Honor.
leave now.
I have constitutional.
You may
violations.
leave now.
Let's go. Let's go.
I have a right to a
You may
counsel.
leave.
Do I not have a right to a counsel?
You want an attorney, you may get on an attorney, sir?
I need somebody to explain the problem here.
Do you wish to be represented by an attorney on this?
I do not need to represent myself. I'm presenting myself. I'm the only one that was there in this courtroom. No one was there. I don't recall anybody that was there that day. I'm the only one that knows what happened, Your Honor.
Do you wish
And I was
to be
violated.
represented by an attorney? I'm not going to sit here and argue with you. If you wish to be represented by an attorney,
Your Honor, I have constitutional violations
do
that need
you
to
wish to be represented by an attorney,
You
sir?
take an oath to defend the Constitution of the United States of
Then
America.
if you do not want to answer,
This is a final escalation, a decisive moment where the judge exercises full authority to maintain order in the courtroom. Removal from a courtroom is not a light action. It typically happens when a defendant is seen as refusing to comply with court instructions or disrupting proceedings. From a legal standpoint, the judge must ensure the trial or hearing can proceed efficiently and respectfully. If a participant repeatedly refuses to engage properly, the court has the authority to remove them. However, this moment also leaves us with a deeper question. Was this removal necessary for maintaining order, or could the situation have been handled differently to preserve the defendant's ability to participate? And more importantly, how much patience should a court have when dealing with someone representing themselves under high-stress circumstances?
My question, Mr. Allen, he is to be removed from my courtroom.